Florida law has some common misconceptions, and I'm going to cover four of them, the four kind of biggest ones that I hear sometimes and you see are repeated on the internet or in person. I don't want people to be fooled by the information that they hear, so I'm going to try to clear that up. The first thing is arrest always leads to conviction. This is not correct. Conviction requires a plea or a trial. You are entitled to due process. DUI, having to do with DUI refusal. And the most common myth about that is a DUI refusal to blow means you can't be convicted of DUI. I'm going to go into that. The blood alcohol content is just one method of proving impairment. So the third common myth is stand your ground, has to do with Florida's stand your ground law, which is a self-defense law. That means you can always use deadly force. That is not correct. You have to believe you're in imminent danger of serious harm or death, and it has to be proportional. And lastly, the fourth myth is that you have to speak to the police or answer their questions. That is also not correct. You have the right to remain silent. Myth number one, an arrest means you're guilty. That is not correct. Let's start with this one. Just because you've been arrested doesn't mean you'll be convicted. So, under the U.S. Constitution, the Fifth and Sixth Amendments of the U.S. Constitution, and also the Florida Constitution, some people don't know that Florida has its own constitution as well. Florida Constitution, Article 1, Section 9, you have the right to due process. So, what that means is, in this context, is a conviction only occurs after a plea, a plea, that's like a plea of guilty or no contest, voluntarily entered, or after a trial where the state has to prove you guilty beyond to the exclusion of every reasonable doubt. So the trial can be a jury trial or a bench trial, but they needs going to be one of those things are going to be necessary to have a conviction on your record. Being arrested is merely the beginning of a criminal process, not the end. So that's the two things shouldn't be conflated. You still have rights, and we're here to defend them every step of the way. That would be my role as a defense attorney. So that's the first myth I want to kind of address and make sure everybody's really clear on that. Myth number two, refusing a breath test that has involving DUI. Refusing a breath test means you can't be convicted of DUI. So this is a myth. Many people think refusing a breath test has that effect, but that's not correct. Uh, just because you've refused a breath test doesn't mean you can't be found guilty of DUI. That is simply false. Under Florida Statute 316.193, a person, that's the DUI statute, a person can be convicted of DUI if they are in actual physical control of a vehicle and are either under the influence of alcoholic beverages or controlled substances, so it doesn't have to be alcohol, it could be something else, to the extent that their normal faculties are impaired, or have a blood or breath alcohol level of 0.08 or higher. So impairment is defined in the standard jury instruction, and it can be more complicated about their ability to see and hear and make decisions, things like that. Blood alcohol level is what the breath test is for, is to try to prove impairment under this theory of the BAC in the DUI statute. But it doesn't have to be that method. So even if you refuse a breath test, which by the way can result in a license suspension for refusal to blow, and that's under 316.1932 Florida statutes, the state can still use officer observations or it could be lay witnesses observations, field sobriety exercises, body cam footage, other evidence, driving pattern to show impairment or statements a person has made. So all those things can help show impairment and try to get the state can try to get a conviction. So refusing to blow doesn't end a case, but it can complicate. It can certainly complicate a case. Maybe it's more defensible, maybe not. It really depends on the circumstances. So that's a kind of an important decision and how that actually plays out. But the belief that not blowing is going to result in a guarantee of no DUI, that's wrong. So that's myth number two. Myth number three is about stand your ground. Florida has a strong self-defense state, and they have a special law called stand your ground. That's been codified, and the myth is about that. And the myth is that stand your ground means that you can always use deadly force, um, which is not correct. Essentially, it's an unlimited use of force, which is wrong. Stand your ground is one of Florida's most misunderstood laws. You hear people say the wrong thing about it all the time, and they act on it wrongly all the time, which can be really tragic. Now, people assume it gives a blanket license to use deadly force, which it does not, and or deadly force in a confrontation, which is wrong. Under Florida statutes 776 and point oh 0 776.012 and 776.013, you can only use deadly force if you reasonably believe that you using of such force necessary is to prevent imminent death or great bodily harm to yourself or another, or to prevent a forcible felony. So even then, the use of force must be proportional to the threat. So while you don't have a duty to retreat under these statutes, though there are circumstances where you might have a duty to retreat, the law still requires that you have a reasonable belief in an objectively reasonable threat. So it can't just be your own subjective sense of threat. It has to be something that's reasonably recognized by people. Now, misusing this law can be uh, cause you to get criminally prosecuted if you make a mistake about this law and you use that kind of force. That's why you need experienced legal guidance before making some sort of assumptions about things like this. The only time defense attorneys like me are getting involved is usually after somebody's already made a pretty tragic mistake about how they used force. Um, but not always, and you can defend cases like this successfully. But the point is, the thought about what the law says is it can lead to a tragic misunderstanding. So now for the fourth myth, also pretty common, is that you have to talk to the police. Now there's all kinds of circumstances where people believe they have to talk to the police, but this is critical. You are never required to answer police questions without a lawyer present. Under the Fifth Amendment to the U.S. Constitution and Article 1, Section 9 of the Florida Constitution, you have the right to remain silent. You also have the right to an attorney under the Sixth Amendment and the Florida Constitution, Article 1, Section 16. And if law enforcement tries to question you, you can and should say, I am invoking my right to remain silent and I want to speak to a lawyer. Now, remember, anything you say can and will be used against you, and don't give the state evidence to use against you. You can assert your rights. But the decision of whether or not to speak, so that's general kind of concepts, but this isn't legal advice and it's specific to you in your case. I can imagine circumstances where it would be reasonable to speak to the police, but if you believe that you have no choice, that is generally incorrect. There's always a choice involved. So the issue can become whether or not there's something that you say that could be incriminating or being used against you. So if that's coming up, usually that means there's some sort of crime involved, in which case you probably do need an attorney and you need to talk to somebody immediately. But you have rights. Uh, so I think that kind of covers the four main, most common misconceptions about Florida law, and some of which can lead to really bad consequences for you or others around you. And misinformation leads to mistakes. Mistakes can cost you your freedom, your record, your future, and whether you're facing charges or you're just trying to understand your rights. I'm trying to help that everybody has no mistakes about Florida law. You can look these things up. That's why I put them in the content. So if you have any questions or issues that some sort of criminal matter that you need help with and you're in Florida, uh, call me, Matt Landsman, Landsman Law, for you.